Imagine losing like 7% of everything you've worked your entire life to build. I mean, your house, your savings, everything.
Right, and just because you use the wrong piece of paper to pass it on to your kids?
Exactly. Or even worse, imagine a judge, someone who has literally never met you, deciding who raises your children.
It's a terrifying thought.
It really is. Welcome to the Time and Market Deep Dive. Now, before we jump in today, I do need to give a quick reminder that this deep dive is strictly for entertainment purposes.
Right, we're going to be talking about some pretty heavy legal and financial concepts today.
Yeah, so please, always seek professional advice for your own specific situation. Also, let us know in the comments if there are any other topics you would like us to explore in the future.
Definitely.
So today, our mission is to answer one of the most stressful, confusing financial questions you can face. What is the actual difference between a will and a trust, and, which one do you actually need?
It's the million-dollar question.
Literally, in some cases. And to figure this out, we've pulled from a massive stack of sources today. We're looking at legal experts like O.C. Elder Law and Cunningham Legal, as well as financial giants like Schwab and Fidelity.
It's an incredibly weighty topic. I mean, creating an estate plan forces us to confront our own mortality, right? Which is something human beings are naturally wired to avoid at all costs.
Oh, absolutely. Nobody wants to think about that.
But ultimately, this isn't really about death. It's about maintaining control. It's about actively protecting the people you love when you're no longer there to do it yourself.
I really love that framing. But to figure out which of these documents you actually need, we first have to clear up this massive, widespread misconception about what they even do.
Yeah, there is a lot of confusion out there.
Okay, let's unpack this. Think of a will as basically leaving a detailed instruction manual. You write out who gets what, but that manual has to be handed to a judge to actually follow and execute after you're gone.
Right, the judge is the one executing it.
But a trust is like putting all your belongings into a locked safe box right now while you're still alive. You hold the key, and when you pass away, you've already handed a spare key directly to someone you trust.
Completely bypassing the judge.
Exactly.
That's a great way to visualize the distinction, because it really all comes down to timing and authority. Looking through the research from estate planning platforms like Vanilla, there's this persistent, almost universal myth that having a will means you avoid probate.
Wait, let me stop you there, because I think a lot of people listening just had their minds blown. You're saying a will does not keep you out of court.
Not at all. In fact, it's the exact opposite. A last will and testament only takes effect after death, and it actually guarantees probate.
Guarantees it.
Yes. A will is quite literally a letter written to the probate court. And probate is a court-supervised, highly public process. A judge has to legally validate the document, formally notify your creditors, and oversee the distribution of your assets.
Okay, let's dig into the mechanics of that for a second. Why is probate such a nightmare? Going to court doesn't sound fun, obviously, but why does everyone try to avoid it like the plague?
It really comes down to three things: time, privacy, and money.
Okay, so with time.
So probate isn't just a quick meeting. In many states, there's a mandatory waiting period, sometimes 6 to 9 months, just to give potential creditors time to make claims against the estate.
Wow. So your family's inheritance is just frozen during that time.
Exactly, frozen. And second is privacy. Because it's a court proceeding, your entire financial life becomes public record.
Anyone can see it.
Anyone. Nosy neighbors, scam artists, they can look up what you owned, who you owed money to, and exactly who got what.
That is incredibly invasive. And what about the money part? You mentioned earlier that it's a massive financial calculation.
The financial hit is staggering. If you look at the numbers from O.C. Elder Law and Best Lawyers, probate can easily consume 3 to 7% of an estate's total gross value in fees.
Wait, gross value? Meaning before debts are paid.
Precisely. Let's say you own a $500,000 house, but you still owe, say, $300,000 in the mortgage. The probate fees are often calculated on the full $500,000.
That's insane.
Right. We're talking about court filing fees, mandatory legal fees, executor compensation, and paying court-appointed appraisers. On a $500,000 estate, you could lose up to $35,000 to the system.
That's tens of thousands of dollars that should be going to your family, not into the pockets of the court and administrative lawyers.
Exactly.
Okay, well, if probate is that expensive, that public, and that slow, it honestly feels like a will is a trap. Why would a young family with a modest income even bother with a will? Why wouldn't every single person just skip straight to the lock safe box, the trust?
That's the logical next question for sure. If it's so bad, why do it? But it assumes that an estate is only about money and houses.
Ah, right. Which brings us to the first massive reason almost everyone needs a will, even if they have a trust. It's about your kids.
Yes, the kids.
The experts at PM Law and Anderson, Dorn and Rader stress this heavily. The one superpower a will have that a trust absolutely does not have is the legal ability to name guardians for your minor children.
This is the critical piece right here. A trust can hold the money for your kids, but a trust cannot dictate who raises them.
So what happens mechanically if someone passes away without a will naming a guardian? Does the state just, look at the closest relative?
It's much messier than that, unfortunately. If you don't have a will, a judge will decide who raises your kids. And remember, this judge doesn't know you.
They have no idea what your family's like.
Right. They don't know your parenting style, your family dynamics, or that you secretly can't stand your sister's husband. They're going to look purely at statutory guidelines and perhaps who looks the most financially stable on paper.
That sounds like a recipe for a massive family fight.
It absolutely is. It leads to devastating outcomes. You can have sets of grandparents battling in court over custody, just draining the family resources on lawyers. Or, worse, your children could be temporarily placed in the foster care system while the court sorts the mess out.
Oh, wow. Just the thought of that is terrifying.
Yeah.
So getting a will is the baseline defense to make sure you make that choice, not a judge. And beyond guardianship, let's talk about what happens to your stuff if you die without a will. I think the legal term is dying intestate.
Right. Intestate. And intestacy is a very rigid system.
Because essentially, if you don't write your own instruction manual, the state legislature has already written a one-size-fits-all formula for who gets your stuff.
And those formulas are incredibly old school.
Yeah, they look purely at bloodlines and legal marriage. They do not account for modern family dynamics. Like, if you've been with an unmarried partner for 20 years, the state formula does not care. It could give all your assets to a distant cousin you've never met, rather than the person you've built your life with.
If we connect this to the bigger picture, a will is your baseline defense against state intervention in your family's life. It ensures that you are making the decisions about your children and your belongings. It's really step one of adulthood.
Step one of adulthood. I like that.
And for smaller estates, say, under $300,000 where real estate isn't involved, the sources from Johnson, Gesink, and Baxter note that a will might be all you need, depending on your state.
Okay, so if a will covers the baseline and guardianship, at what point should you level up and get a trust?
You graduate to a trust when your life or your wealth reaches a certain level of complexity.
Here's where it gets really interesting. Let's talk about the blended family scenario. There's a brilliant hypothetical from the legal team at Cunningham Legal that perfectly illustrates this.
The Mark and Kim example?
Yes. So imagine a couple, Mark and Kim. Mark has an adult kid from a previous marriage, but he also has a new life and joint assets with his new wife, Kim. Let's say Mark keeps it simple. He just uses a basic will, leaves everything to his current wife, Kim, and figures, hey, she's a good person. She'll make sure my kid gets something eventually.
That is a very common, very dangerous assumption.
Why? What actually happens mechanically in that scenario?
What happens is Mark's adult kid might get absolutely nothing.
Nothing.
Nothing. Once Mark dies and Kim inherits everything through that will, it is legally 100% hers. She has zero legal obligation to give a dime to Mark's child.
Wow.
She could get remarried and leave everything to her new husband. She could leave it all to her own children. Or they could just have a falling out and she writes Mark's kid out of her own will entirely. By trying to keep things simple, Mark accidentally disinherits his own child.
That completely blows my mind. So how does a trust fix that?
Well, trusts are essential for blended families because they allow for staggered, highly detailed distributions. With a trust, Mark can separate the concepts of ownership and benefit.
Okay, how does that work?
He can put his assets in the trust and say, Kim can use the income from this money or live in this house for the rest of her life. So he's taking care of his current spouse. But when Kim passes away, whatever is left in the trust must go to my child from my first marriage.
Wow. What's fascinating here is how a trust allows you to govern your assets from beyond the grave.
Precisely. You can even appoint a professional fiduciary like a bank or a trust company to act as a neutral trustee. That way, Kim and the adult child aren't fighting over every withdrawal. It keeps the peace. That level of nuanced control is simply impossible with a basic will.
Right, because an executor just settles a will, but a trustee manages the assets long term.
Mm-hmm.
And blended families aren't the only trigger. You also need a trust for larger estates, right? Like generally over $500,000, or if you own property in multiple states.
Yes.
Let's say you live in California, but you own a little vacation cabin in Nevada. If you only have a will, your family doesn't just go through probate once. They have to open a probate case in California for your primary stuff and a second, totally separate probate case in Nevada just for the cabin.
Yeah, it's called ancillary probate.
Double the lawyers,
Yeah.
double the court fees, double the waiting periods.
It's awful. That scenario alone completely justifies the cost of setting up a trust. But there's another massive benefit to trusts that people completely overlook, and it has absolutely nothing to do with dying. It's about incapacity planning.
Oh, this is huge. Walk us through how a trust works if you don't die, but you just get really hurt.
So a will only turns on when your heart stops beating. It is completely useless if you are alive but incapacitated. Say you're in a severe car accident or develop advanced dementia. If you only have a will and you become incapacitated, your family has to go to court and ask a judge to grant them a conservatorship.
Just to access your checking account to pay your mortgage or medical bills.
Exactly. And conservatorships are famously messy and expensive.
Oh yeah, they are awful. You're paying lawyers to prove you are incompetent.
Right. But a revocable living trust works while you are alive. If you are incapacitated, the person you already named as your successor trustee just steps in seamlessly. No court, no judges. They just go to the bank, show the trust document, and start managing your bills.
That is such a massive layer of protection for your family. And while we're talking about taking care of people who need help, there's a specific type of trust for special needs, right?
Yes, a special needs trust. If you have a child or a beneficiary with a severe disability, leaving them a chunk of money in a standard will can actually be disastrous.
How so?
Well, inheriting $50,000 could instantly disqualify them from essential means-tested government programs like Medicaid or supplemental security income.
Ah, because suddenly the government says, hey, you're too rich to qualify for this care anymore.
Exactly. A special needs trust holds the money in a way that provides for their extra care and quality of life without technically counting as their personal assets. So it preserves those vital government benefits.
Okay, so we've established the camps. We know why the baseline will is crucial for guardianship, and we know why leveled up trusts are game changers for blended families, real estate, and incapacity.
Right.
So let's talk about the wallet impact. What does it actually take to set these up?
This is where people often get sticker shock, but you really have to look at the total life cycle cost. It's a classic pay now or pay later scenario.
Let's break down that trade-off. According to OC Elder Law, wills are pretty cheap up front. You might pay an attorney $300 to $600 to draft a solid, simple will,
Right.
but they are incredibly expensive on the back end because of those 3 to 7% probate fees we talked about earlier. Trusts are the exact opposite. They are a heavy upfront investment, usually between $1,500 and $3,500 or way more if your estate is super complex, but they save your family massive amounts of money and time post-death.
It's important to note, too, that geography plays a massive role in this math.
Really?
Yeah. The Barley-Snyder source points out that in states like Pennsylvania, probate is actually a relatively streamlined, reasonable process. The fees aren't astronomical. So in PA, a simple will might legitimately be cheaper overall.
Interesting.
But if you look at a state like California, where probate fees are strictly set by statute and are notoriously high, a trust is practically mandatory if you own real estate.
So location changes the math completely.
Yeah.
Okay, so what does this all mean for the listener's weekend? Let me ask you a pointed question about the setup process.
Sure.
Let's say I write the check, I pay the lawyer $3,000, they hand me a beautiful leather-bound binder with my new trust inside. I put it in my desk drawer, lock it, and go hit the golf course. I'm totally protected, right?
That is the most dangerous trap in estate planning.
Oh boy.
It is the quickest way to completely waste $3,000.
Why? I signed the papers.
Because a trust is a useless, empty shell unless you fund it. I cannot stress this enough. Creating the legal document is only step one. Step two is funding, which means you must legally retitle your assets into the name of the trust.
Okay, mechanically, what does that actually look like?
It means you have to go to the county clerk's office and file a new deed for your house. Your deed can no longer say it's owned by John Doe. It has to say John Doe, trustee of the John Doe Living Trust.
I see.
You have to actually go down to your bank and change the ownership of your checking and savings accounts so the trust owns them. You have to log into your life insurance portal and update the beneficiaries so the trust receives the payout.
So if I skip that step, put the binder in my desk, and go play golf.
If you skip that step, the trust owns nothing. And when you die, all those assets that are still in your personal name go straight to probate court anyway.
That is brutal.
It is, and it happens far too often because people assume that once the lawyer signs the paper, the job is done. You have to do the homework. You have to actually move the assets into the safe box.
That is a harsh lesson. All right, so we've spent this entire deep dive treating this as a versus battle, will versus trust. Like you have to pick a side. But what did the experts actually conclude? It's not an either situation, is it?
Not at all. In fact, if you do it right, they work together as a unified system. You almost always need both.
Right. If you get a living trust, you must pair it with a very specific type of document called a pour-over will. So pour-over will is basically the estate planning equivalent of sweeping the floor. It catches all the stray assets or dust bunnies you forgot to put into the trust and sweeps them right into the dustpan.
Right. That's a highly accurate, if slightly messy analogy. It really is the ultimate safety net.
Because let's face it, life happens. 5 years from now, you might buy a new car or open a new high-yield savings account, and you just completely forget to title it in the name of the trust.
Exactly. When you pass away, those forgotten assets are technically stuck outside the safe box. The pour-over will essentially tells the probate judge, hey, anything I accidentally left in my own name while I was alive, please transfer it immediately into my trust.
Now, that stuff still has to go through probate, right? Since it was outside the trust.
Yes, unfortunately it does, but the vital part is that once it clears probate, it gets poured into the trust, ensuring that your master blueprint, your staggered distributions, your protective rules for your kids still governs how that asset is finally distributed.
Makes sense. Okay, there's one major expert warning we need to highlight before we wrap up, and this comes from the financial team at Kiplinger. When you go to set up a trust, the lawyer is going to use terms like revocable and irrevocable. The experts warn that you should avoid irrevocable trusts unless you're in a highly specific, extreme situation.
This is a crucial distinction. For 99% of people listening, a revocable living trust is the right choice. Revocable means you can change it, cancel it, rewrite the rules, or pull your money out of it whenever you want. You retain total control while you are alive.
But an irrevocable trust.
With an irrevocable trust, you permanently surrender control. Once you put a house or money into an irrevocable trust, you cannot easily change your mind. You usually aren't even allowed to be the trustee anymore.
So why on earth would anyone ever do that?
Because giving up control creates an ironclad wall. You only use an irrevocable trust if you need extreme creditor protection.
Give me an example.
So if you are a brain surgeon and you are highly prone to massive malpractice lawsuits, an irrevocable trust shields those assets because you technically don't own them anymore.
I see.
The other main reason is Medicaid planning. If you anticipate needing expensive nursing home care, putting assets into an irrevocable trust years in advance can legally remove them from your net worth, helping you qualify for government assistance. But for the average person, stay far away.
So revocable is the way to go.
Definitely. And this raises an important question about maintenance. Your dustpan analogy earlier really highlights that estate planning is not a one-and-done event. It is a living, breathing process.
Set it and forget. It does not work here.
Exactly. You buy a new property, you have more children, tax laws change, relationships evolve. You cannot just put these documents in a drawer and forget them for 30 years. They require periodic review, maybe every 3 to 5 years, to ensure they still reflect your life, your assets, and your wishes.
That is fantastic advice. All right, let's quickly recap what we've learned today to make sure it sticks. Wills are your essential baseline. They are relatively cheap upfront. They are the absolute only way to name guardians for your minor children, and they work well for simpler estates.
Right.
But they guarantee your estate goes through the public, slow, and potentially very expensive probate court process.
And trusts require a heavier upfront financial and time investment. But they offer total privacy, they completely bypass the probate court, they allow for complex, staggered family distributions, and they protect you seamlessly if you become incapacitated while you're still alive.
And most importantly, if you do choose to level up to a trust, you must do the homework. Fund it by actually retitling your assets, and pair it with a pour-over will to catch any of those dust bunnies you miss. We want to thank you for joining us on this deep dive. We know estate planning isn't exactly a light, breezy topic, but taking the time to understand this and treating it with the attention it deserves is quite literally one of the greatest gifts you can ever give to your family.
It truly is a profound act of love. It saves them from stress, confusion, and conflict during the hardest moments of their lives. And to leave you with a final thought to ponder, inspired by a fascinating point in the best lawyer source, we've talked heavily today about physical assets, right? Houses, bank accounts, cars. But what about your digital assets?
Oh, wow, that's interesting.
Think about your photo libraries, your cryptocurrency wallets, your massive email archives, your social media accounts. If a will becomes a public record in probate court, do you really want your entire digital life and your accounts exposed for anyone in the public to search?
I certainly don't.
Think about how a private trust might just be the ultimate firewall for protecting your digital legacy.